Hello there, Cheng here again, an enrolled agent, the author of Beating the IRS Tax Squeeze. This video will be all about the Federal Tax Lien. What? You mean the IRS is still after you and you still refuse to pay? What happened, and what are you going to do about this federal tax lien on you? First, let's make the distinction between a levy and a lien. A levy is a legal seizure of your property. It actually takes away your property from you. A lien is a claim used as a security for what you owe the IRS, namely the government. A lien is also a public announcement to all your creditors that now the government has a right to all your current assets and all the assets you might acquire in the future. It attaches to all your properties, your home, your car, your jewelries, and even the shirt on your back. It also attaches to all your rights to your properties, such as your bank accounts and investment accounts. Once a lien is filed against you, your credit rating will go down the drain. You won't be able to get another loan or get another credit card. You won't be able to sign another contract or lease. And the IRS will release this lien on you 10 years after it filed against you. That means the IRS will have 10 years to come after you and make you pay. Will you be able to live happily, or rather peacefully, for the next 10 years with the IRS constantly on your back? Even after you pay the IRS and they release your lien 30 days after they received your full payment, your credit rating will continue to suffer because it will take another 7 years for your lien to be expunged from public record. So what are you going to do with this federal tax lien on you? You can pay by the following 3 methods. 1, pay in full or submit a bond that will guarantee IRS your payment. 2, you can always apply to pay by installments. 3, you may submit Form 656, Offer in Compromise, by which you may be able to pay less than what you really owe the IRS. But first, you must submit Form 433A, Collection Information Statement for the individuals, on which you must list all your assets. I think this is just a good way for the IRS to find out where you have stashed away all your assets. If you will still maintain that you don't owe the IRS anything, good for you. You have the following 2 options. You can apply a collection appeals program hearing, a CAP, and then both you and the IRS have to abide by the decision of the appeals officer. the taxpayer usually loses, because all the IRS need to prove is that they have sent you all the proper notices. 2, you can apply for a collection due process hearing, and in that a CDP. And in that case, if you still disagree with the appeals officer, you can take the IRS to a tax court. But keep in mind that taking the IRS to a tax court would take at least another year or more for you to settle your case. But some good news here, to be sure. Since 2007, you no longer have to pay your tax assessment up front in order to go to a tax court. Just imagine if you were assessed for tens of thousands of dollars, and you no longer need to engage a tax attorney or an enrolled agent to represent you in a tax court, because you can represent yourself. But keep in mind that 90% or more times the taxpayer still loses, even with good tax professional representation, because the IRS will always have their own good attorneys to defend themselves. By all means, give the collection due process a hearing a try before taking the IRS to a tax court. And cheer up, it's not the end of the world. If I survived, so will you. This concludes my 5 video segments on the IRS tax squeeze. For details, read my book, Beating the IRS Tax Squeeze, or go to my website, www.qianebooks.com. Good luck, and I wish you all the best and smooth sailing with the IRS in all the years to come.